Hello and welcome to day 2 of the New Mexico Black Lawyers Association's virtual Social Justice 101 Lunch and Learn. Some of this may be repeated if you joined us yesterday, but for those who are new, my name is Asia Brooks and I'm the president of the New Mexico Black Lawyers Association. I would, of course, like to thank the City of Albuquerque's Office of Civil Rights for co-sponsoring this event and the members of the Executive Board of the New Mexico Black Lawyers Association for their work on putting the CLE together. So our virtual housekeeping of the day. The sessions will be recorded. The chat function has been disabled and the only video will be of the presenters and moderators. However, we will have a question and answer period at the end of the session. If you do have a question, please type it into the Q&A box and we'll try to answer as many questions as we can after the presentation. We want this to be a safe space, so please, you're only going to be able to see the answered questions. Today's first presentation is approved in New Mexico for 1 hour of general CLE credit, and the second presentation is approved for 1 ethics/professionalism credit. That means if you would like to receive credit for both hours, you must attend both sessions. If you are an attorney or paralegal seeking CLE credit, please make sure to email your name and bar number to us at nmblacklawyers@gmail.com. That's NM as in New Mexico, Black Lawyers with an S @gmail.com. One word, no spaces. That way we can ensure that you receive your CLE credit. If you have already sent us your bar information, you do not need to do that again. All right, so let's get started. Today's topics are risk assessment algorithms, discrimination versus transparency by Dr. Cris Moore, and the Commission on Equity and Justice by Justice C. Shannon Bacon and Torri Jacobus. You will not need to log out between the sessions. So first, I'm going to introduce our first speaker, Dr. Cris Moore. Dr. Christopher Moore received his BA in Physics, Mathematics, and Integrated Science from Northwestern University and his PhD in Physics from Cornell. From 2000 to 2012, he was a professor at the University of New Mexico with joint appointments in computer science and physics. Since 2012, Dr. Moore has been a resident professor at the Santa Fe Institute. He has published over 150 papers at the boundary between physics and computer science, ranging from quantum computing to the theory of social networks and efficient algorithms for analyzing their structure. Most recently, he has worked with colleagues at SFI and UNM to form the Interdisciplinary Working Group on Algorithmic Justice, which seeks to advise policymakers and community advocates on issues of fairness and transparency in algorithms ranging from housing to criminal justice. Welcome, Dr. Christopher Moore.
Thank you very much. So shall I go ahead and share my slides now?
Yep, you can go ahead and do that.
Okay. Thank you very, very much for inviting me. I have to say I'm more excited about speaking to you all today than I am to give the usual seminar or colloquium at a university computer science department. It's so vital that we broaden the discussion of algorithms and their strengths and their weaknesses outside the ivory tower. And I'm especially happy to be working with these folks, some of whom you know. These are people in the political science, computer science, and law departments at UNM, and various social scientists and statistical people and data people at the Santa Fe Institute. And as you just said, our goal is to act as a resource to policymakers in New Mexico and elsewhere. So we've presented to the Criminal Justice Reform Subcommittee of the legislature. We've met with various policymakers, and we want to demystify algorithms, right? Algorithms are portrayed by various people either as these incredibly sophisticated crystal balls that will make fantastically accurate decisions, or at the other extreme, evil plots by artificial intelligences to control all our lives. And so we're trying to piece all of this out and make it clear to everybody what they can do, what they can't do, and what questions we should ask about them. So algorithms are increasingly used in high stakes decisions, decisions that really affect human lives and human liberties, civil liberties, including housing and lending, whether you're approved for a mortgage or a loan or a lease. In predictive policing, the claim is that algorithms can help police departments allocate their resources and their patrol officers and even identify likely perpetrators or victims of crime. In some places, algorithms are being used in social services agencies, for instance, to recommend whether a caseworker should actually be sent out on a call to Child Protective Services or not. And in criminal justice, algorithms of various kinds are being used at every stage of the process, from pretrial supervision and detention through sentencing, classifying what type of housing classification or supervision you should have as a prisoner, and in some states, whether or not you should be paroled. Now, I'm really excited, especially because I'm working with Professor Gibson Rankin and Dean Mathewson on housing issues, and we and other members of our group have been analyzing and commenting on proposed rules from HUD, the Housing and Urban Development Department of the federal government, on how they want to handle claims of disparate treatment and how they're going to handle discrimination cases. I would love to talk about that in the discussion if we have time, but because that work is kind of very much in progress right now, I'm going to focus instead on the use of algorithms in criminal justice. But of course, some of the same questions apply to all these different applications. So what is an algorithm anyway? Well, at its most general, algorithms are some recipe or some if-then framework that says, if this is true about an applicant or a defendant, then the algorithm will recommend this decision, and if that's true, it'll recommend that decision. But in particular, the algorithms that are being used in criminal justice often come from this field variously called machine learning, or, although I don't think this phrase is really a good one, artificial intelligence. And in this space, they're often also called risk assessment instruments, actuarial tools. These are all synonyms. Sometimes an algorithm is something that's run by computer software, but in some cases it might even just be a checklist, a worksheet, where some staff person fills out a worksheet and various responses are worth various points, and then they add them up. That's still an algorithm. It's still a mathematical procedure that arrives at some kind of recommendation. So what do these algorithms do? They take some kind of input or data about a defendant, such as information from their criminal record. These algorithms have been trained on a database of past cases, typically from other times and places. They could be jurisdictions all across the country. That's the training data. And so using some mathematical process, the people who developed the algorithm looked for statistical patterns in that training data. Now, fundamental to the use of these algorithms is the assumption that this defendant in front of a judge now will have similar behaviors or similar outcomes to defendants who looked similar to them in that training data, for instance, who had similar criminal records. Based on that assumption, the algorithm then gives some sort of score or some kind of probability that the defendant will have various behaviors. These might include failure to appear to one or more of their court hearings, new criminal activity, which means being rearrested while awaiting trial. Of course, that's not quite the same as committing another crime. Perhaps recidivism if they're paroled. Within the prison system, the algorithm might be attempting to predict whether they will commit infractions against guards or fellow prisoners, and so on. Now, there's a star up there on that statistical patterns because it's true that the design of an algorithm is solving a math problem. And in that respect, it's objective and unbiased. And so, but the choice of what math problem it is solving is very much a human choice, very much a policy choice, and possibly a very subjective choice. So the question of what type of data about a defendant are we going to look at, and what type of pattern are we going to look at in the past data and then assume applies in the future to future defendants as well, those are human choices and policy choices. And we'll see I'll compare two different algorithms that have made different choices about that. For instance, to, kind of as a spoiler, how much should we care about past arrests versus, say, past convictions? That's a human choice. What type of characteristic about a defendant we should pay attention to? Now, there is overwhelming evidence that human decision makers that are involved in the criminal justice system are historically very biased, and that people in protected classes, especially people of color, are subject to different behavior than, for instance, white people, all the way through the process, whether or not you're arrested, what you're charged with, how often you're convicted, how long your sentence is, whether you'll be paroled, and so on. So given that humans have all of these biases, both explicit and implicit, overt and covert, the proponents of algorithms argue that, look, let's try to make decisions, or at least recommend decisions, in a way which is free from human biases. That's the goal. That's the proponent's argument. And I think I want to make it clear that I think the motives of the people behind algorithms are generally very good motives. They want to get away from historical racism. They want something which is more accurate, less biased, and more objective. Now, the claim that a given algorithm is going to be more accurate and less biased than human decision making, well, this claim may or may not be true, right? This is a claim which needs to be tested. And in order to test that claim, we need transparency. We need to be able to observe the algorithm's behavior. Ideally, we need to be able to look inside it and see how it works to see if it is indeed accurate and fair. Now, in computer science, transparency is often taken to mean something rather narrow, namely, if you've heard of open source software. This is software where the program, the source code that the computer is running, is available to everybody. That's actually a rather narrow definition of transparency. We want more than that. So we want to understand how the algorithm works, and indeed we want society to understand. We want the defendants who are affected by it to understand. We want the prosecutors and the defense attorneys, the judges who are considering its recommendations. We want everyone to know how it produces a certain score that says, oh, this person is high risk or that person is low risk. We don't want it to be a black box. We also want to be able to validate its performance independently. And even if it has done well on that training data, remember, which could come from other times or places, we want to be able to measure how well it does here on our local population in New Mexico, both in terms of accuracy and fairness. We also want to dig into the data. And as we'll talk about, in a lot of data sets that algorithms are trained on and that they use, we might code, for instance, whether you failed to show up to one of your court hearings as a single 0 or 1. We might code whether you've been rearrested as a single 0 or 1. Well, we might want to know much more than that. Did you fail to show up because you're trying to escape justice, or because you lacked transportation and were worried about losing your job? If you were rearrested, was it for a serious charge or a not so serious charge? So we might want to look beyond those zeros and ones to understand whether the data really means what we think it means. Finally, if I have time, the most basic question about an algorithm is, should we use it? And I think that it's important for us to have a public discussion about whether there are certain decisions which really should be human decisions with, warts and all. And in particular, should algorithms alone ever be used to justify detention pre-trial, as opposed to, for instance, various levels of supervision, checking in with the police, and so on? So we'll talk about that. Okay, good. So this first question, this first type of transparency, how does the algorithm work? It says, oh, you should be, in some states, you should be paroled, you should not be. How did it come up with that recommendation? So imagine that there are two kinds of people, green and red. Now, these are not races. These are behaviors that we're trying to predict. So there's some ground truth about who's green and who's red, which, so the green people are low risk. They will show up to court. They will not be rearrested while awaiting trial. In the housing context, they will pay their mortgage, they'll pay their rent on time, and so on. The red people are high risk. If we release them, they will commit another crime or fail to show up to court, and so on. So this division from top to bottom, this is the so-called ground truth, what, the actual fact of the matter. Then an algorithm, or for that matter, a human decision maker comes along, and based on various facts, various data about these people, it makes a division, which I have here between left and right, about who's low risk and who's high risk. So on the upper right and the lower left, you see these boxes containing people that the algorithm got right. So on the upper right are people who are genuinely high risk that it thinks is high risk. On the lower left are people who are genuinely low risk, and it labeled them that way. But of course, there are errors. So on the lower right, we have false positives. These are people who the algorithm thinks are high risk, but are in fact low risk. It thinks that they shouldn't get the loan, but in fact, they would pay the loan back if you gave it to them. It thinks that they would commit a crime if released, but in fact, they would be good citizens if released. On the upper left, we have the opposite kind of error, false negatives, people that the algorithm thinks are low risk, but indeed would be, say, a danger to public safety if released. Now, it's important to recognize that these two types of errors, false positives and false negatives, every decision-making process, every attempt to classify or predict what people will do, whether it is a computer or a human or a combination, is subject to these two kinds of errors. And of course, reading about COVID, we know that diagnostic tests can also have false positives as well as false negatives. Now, these two different types of errors have two different kinds of costs, both to the person that we're trying to predict and to society at large. And in the legal context, of course, this is a real debate. So here is the great jurist William Blackstone, who said he was very concerned about false positives. In other words, he does not want us to imprison people who are innocent, and he's willing to let some guilty people go in order to avoid imprisoning innocent people. Here is another decision maker in society who is concerned more about false negatives. It was, in his opinion, okay for some innocent people to be incarcerated at Guantanamo as long as we caught the actual terrorists. So this is a deep philosophical debate about how we should weigh these different sorts of errors in society. Of course, in the judicial context, we have specific notions about innocent until proven guilty and so on. So how do these algorithms work? What do they try to do? Well, what many of them try to do is assign people a risk score. Again, we have green folks and red folks. And it tries to, if you will, line them up from lowest risk to highest risk by assigning them some kind of number which indicates how risky they are. What are the chances that they will commit another crime if released, for instance? Now, if this score were perfect, well, there would be some threshold below which everybody's green and above which everybody's red. If that were the case, then you know what to do. Everybody above that score, you should say, well, detain. And below that score, you should not. But of course, people are hard to predict. Data is noisy. There's a lot of uncertainty in the world. So the situation is much more like this. The most we can hope for is that this score is imperfectly correlated with behavior or with outcomes, so that there might be more red people above some threshold and more green people below it. But there will be false positives. So those are green people who, if we set that threshold at that dotted line, will be deemed high risk even though they're not. Well, of course, you could reduce the number of false positives by raising that threshold, but then you would increase the number of false negatives, and you could, lower the threshold and so on. But the fact is, wherever you place this, there are going to be errors of both kinds. And again, that's just a fact about classification or prediction, whether it's humans doing it or an algorithm doing it. Good. Now, given that there's this kind of mix of different sorts of errors, how do we even talk about how accurate these risk scores are? Well, if you dig into the literature, you'll find that the companies and people who work on these scores use a measure of accuracy called the AUC. There's a lot of three-letter acronyms in this business. This one embarrassingly stands for area under the curve. And so we read sometimes, oh, this risk assessment algorithm has an AUC of 0.7, and that's supposed to be good. Well, what does that mean? Does it mean it's 70% accurate in some sense about individuals? No, not exactly. Here's what it means. It means that if we could magically choose a random person from among all the genuinely high-risk people and a random person from among all the genuinely low-risk people, it means that 70% of the time, if the AUC is 0.7, that it would correctly assign a higher risk score to the person who's actually high risk than the person who's actually low risk, okay? So here is another pair that it would get right, giving the red person a higher score than the green person. But on about 30% of the score pairs, about 1/3 of the time, it would incorrectly give a higher risk score to the green person, the person who is not in fact high risk, than to the red person, all right? Why am I going through all this? Well, one reason is that whenever you hear the vendor of an algorithm say, oh, something is 90% accurate, well, what does that even mean, right? That's not actually a well-defined set of words. And it's in many cases important to dig in and figure out what they're actually saying. So you should never accept a claim that just says 90% accurate. In what sense? What mathematical definition of accuracy is being used? But the other thing I want to point out is that here, it's important to recognize that especially in the criminal justice space, there is a lot of uncertainty. In medical diagnostic testing, for instance, an AUC of only 70% would be considered unacceptably low. We wouldn't even deploy that kind of diagnostic test unless it was 80% or 90%. That's when we would start to consider it useful. So anyway, that's something I wanted to point out. Good. All right, now, and I need to watch the time here, let's look at two popular algorithms that are used in various jurisdictions for various applications in criminal justice that are in some sense at the opposite ends of the spectrum of transparency. One is called Compass, and it was developed by Northpoint, a company now called Equivant. It uses a lengthy questionnaire, and it uses a proprietary formula, a secret formula, to translate the answers to that questionnaire into a risk score. The other is the Arnold Public Safety Assessment, or PSA. It's being used now in a lot of jurisdictions, including several in New Mexico. It uses just 9 factors from the criminal record of the defendant, and then uses a simple transparent formula to translate that into a risk score. So let me show you a few pages from Compass's questionnaire. It asks, how many times were you arrested, including as a juvenile for felonies or violent felonies? It asks, who raised you? Your natural parents, adoptive parents, foster parents? Was your father or your mother, were they ever arrested that you know of? It asks, do you have a lot of contact with your family? Have you moved around a lot in the past 12 months? Have you been living at your current residence for a while? Is there a telephone at your current residence? Tell us about your education. Did you finish your high school diploma or your GED? What were your grades like? And so on. It has lots of other questions. Do a lot of your friends belong to gangs or take drugs? Do they feel they need to carry a weapon, and so on? Now, one concern about Compass is it is a black box. So the results of the answers to these questions are then put into a formula to develop a risk score. We know what kind of formula it is. It's not terribly sophisticated. It's something we teach to undergraduates in computer science courses. It's called logistic regression. Don't worry about it. But we don't know how much weight, how much importance, if you will, how many points Compass gives to each of these questions, and then how it combines those to get its risk score 1 through 10. So that's concerning, because it is a black box. We know what data it uses, we know what questions it's asking, but not how it's using that data to arrive at a score. Secondly, all these environmental questions about your upbringing, your neighborhood, to be fair, I can imagine that those questions might be useful in recommending social services. If you're trying to figure out what kind of social services I need, for instance, to help me reintegrate into the community after being released from prison, it might help to know what, am I living in a high crime neighborhood? Do I have a stable social network, a support network, and so on? But it seems clear that these sorts of questions about your upbringing, who raised you, for instance, should have played no role in pretrial or the length of your sentence or whether or not you should be paroled. These are things that you had no say over, especially your childhood. And of course, also, we live in a society where you live and how you were brought up is sadly correlated with things like your race, and not to mention your income and your economic class. Now, it's important to note that the questionnaire does not say anywhere how much money do you make or what color are you. So on the face of it, it looks as if it's not biased. But because it asks questions about these social factors that are correlated in our society with being a member of a protected class, such as being a person of color, there is at least the potential for bias. And we've seen this before. So for instance, I don't think I need to tell you that long after it became illegal to deny a mortgage or a home improvement loan to someone because of the color of their skin, there were still these redlining maps where I would say, oh, well, I'm not racist, but because you live in this particular neighborhood, which is declining or hazardous as opposed to desirable, I'm not going to give you a loan. And so for a long time, the use of that proxy variable, not race, but something correlated with race, allowed allowed housing to continue to be very biased until, well, and this is still being fought through the Fair Housing Act. Now, I want to be absolutely clear here. I am not claiming that the designers of Compass or the users of Compass have any intent to be biased against people of color or low-income people. Whereas I think the people who made these redlining maps had, in many cases, exactly that intent. So I'm not claiming that there's any intent of bias behind the designers of Compass, but it's important to recognize that even if an algorithm does not use race or class or other protected variables directly, it has the potential to be biased through correlations with other variables or combinations of other variables. Those things called proxy variables. Now, the other issue, of course, in the criminal justice system is that, I deserve an explanation of why I'm being treated by the state the way I'm being treated, especially if my civil liberties are being denied. So a number of states use Compass to make recommendations to parole boards about whether someone should be paroled. So in New York, a gentleman named Glenn Rodriguez, who had served multiple decades for a murder committed as a young man, he was denied parole because the prison staff incorrectly told Compass, they checked a box incorrectly saying that he had had a terrible disciplinary record, whereas in fact he had had an exemplary disciplinary record. Extraordinarily, he even got the prison to put in writing that they had, admitting their mistake, but they never got around to putting the correct data into Compass and updating his score. And since Compass is a black box, he did not know how much that mattered, although anecdotally he knew from fellow prisoners that it mattered a lot. So he was not even able to tell the parole board what his score would have been if Compass had been given the correct data. Again, because it completely lacks that transparency. So 2 years later, he came back to the parole board and they took the unusual step of overturning Compass's recommendation and releasing him, which as you can imagine, in these post-Willie Horton circumstances, it is a huge political risk to release someone that an algorithm says is high risk to the public, even if you feel there are other things about them that would suggest they're not a high risk. So, this is the kind of thing that I would be very concerned about. in using an opaque algorithm like Compass anywhere in the criminal justice system. And I don't think, frankly, that that kind of opaque algorithm should play a role in the criminal justice system at any stage. Now, at the other extreme of transparency, here is the Arnold PSA. So it does not use that lengthy questionnaire, and it does not use the data in some opaque way. The entire algorithm is right there on the screen. It uses information about your criminal record, and it gives a certain number of points to various factors, such as prior convictions or prior failure to appear. It gives specific risk scores 1 through 6 for failure to appear and for new criminal activity, which again means being rearrested while awaiting trial. It's used in a bunch of states, and here in New Mexico, it's been used in Bernalillo County for a while and has been rolled out now in pilot projects in Sandoval and San Juan. And it's not a black box. Everyone can see how their score was developed. Now, there are still lots of good questions you can ask. You could still say, well, wait a second. Why is, for instance, why is 1 to 2 prior felony convictions worth this many points and 3 or more is worth that many points? Those are good questions. Those questions should be asked. But at least it's transparent in saying how it works. Now, I mentioned before, remember, that it is a human decision, a policy decision, what type of data to use about a defendant. And so, for instance, unlike Compass, it does not use past arrests. Why? Well, frankly, there is a consensus in this business that whether you've been arrested in the past is not a very good guide to your future behavior for several reasons. One is some people get arrested a lot. Some people get arrested for hanging out with their friends on street corners. That has never happened to me. Homeless people get arrested very often, even if they're arguably not a danger to public safety. And it seems that being arrested is one of those things which is strongly correlated, strongly biased against certain demographic groups. So the people who put together the Arnold PSA decided we're not going to use arrests. We are going to use convictions. And convictions are also historically biased, but hopefully less so than arrests. Okay, so this is the kind of human choice or policy choice which goes into the design of these algorithms. It does also not use the juvenile record. I think that's very interesting, presumably because you should get another chance when you come of age to put your juvenile behavior behind you. And it does not use any of those environmental questions about your employment, your education, your childhood that Compass uses. Good. It does use age, by the way, but not gender. That's interesting. All right, so good. So we had that first level of transparency. How does the algorithm work? Well, now another level is how well does it work? If we actually roll it out in New Mexico, will it be accurate and will it be fair on our local population? Here is some stuff from a recent manual put out by the National Association of Pretrial Services Agencies. And they argue, for instance, that you should, if you're going to use one of these risk assessment algorithms or tools, you should review it routinely. You should not use opaque screening criteria, and you should validate it on your local defendant population, including checking to see locally if its results are correlated with race. Why is this important? Well, again, every population is different, and that training data that algorithms are developed on comes from other times and places. New Mexico's demographics are unique to this state. And also, of course, each jurisdiction implements these algorithms differently. Some might use it on misdemeanor cases, others on felony cases, and so on. So algorithms based on training data from other times and places may really perform differently here in New Mexico, and we'll see an example of that in a moment. Another more subtle point is that because it takes time to develop algorithms and to deploy them, the training data is always several years old, and that means that it might not take new developments like positive interventions into account. One example is, suppose that your jurisdiction has realized, as many jurisdictions do now, that you can help people show up to court and be treated fairly by the system If you send them text message reminders that are well designed and kind of ramp up to their court date saying, look, this is really important. You don't want a warrant out for your arrest. Let us know if you need transportation and so on. And indeed, there's a lot of studies that these text message reminders can help people a lot. Well, if data from a couple years ago, right, is from places that had not yet put those interventions into place, I might be a defendant that you would correctly guess that without that program, there's a high chance that I won't show up to court. And you might then say, oh, well, you better detain me. Well, that would be terrible, right? To disrupt my life by doing that, and also cost the taxpayers money. If instead you should be using that positive intervention. So that's another interesting point, right? The outcomes are going to change as different interventions are put into place. Good. So we need to check that this thing works as well as advertised. And of course, it goes without saying that these studies should be done independent of the vendor, if there's a private vendor, and for that matter, independent of the agency that contracted with them. Now, here are some results of some actual studies like this, that to their credit, the Arnold Foundation, now called Arnold Ventures, supports these studies to see how well their PSA, their public safety assessment, actually works. There's a lot on this graph. Let me zero in on something. So remember that the PSA gives these 1 through 6 scores in several categories, 1 for failure to appear, 1 for new criminal activity. Let's zoom in on the middle box here. That's for new criminal activity. So 1 through 6 going across the bottom is what score the PSA gives you. And then these blue boxes at the top are from the national training data, which was gathered from jurisdictions all over the country. With what probability, how often, with what chance somebody who got, say, a 6 was rearrested? And you see that was 55%, more than half. You know, so if a judge knew that if she released me, the chances were better than even that I was going to get rearrested for another crime, well, of course, she would think about whether or not she should do that. But now let's look at the green circles and the yellow stars. This sounds like a Lucky Charms commercial. Those are follow-up studies. The green circles are from Kentucky. The yellow stars are from New Mexico, done by the Institute for Social Research at UNM. And what you see there is that among those people who got the highest risk score, a 6 on the 6-point scale, in Kentucky and New Mexico, the chances that they were rearrested was 26 or 29%, about half of what it was in the national training data. Well, that's really interesting. And that's a much larger difference than you could explain just by kind of random sampling or statistical error. We don't know why this is so. We don't know if people in New Mexico and Kentucky are just nicer than people elsewhere in the country, but it does mean that when judges and prosecutors and so on are trying to figure out what does a 6 mean, right? Because of course, who cares that there's this abstract score, it's a 6. The question is, well, if we release you, what are the chances that you will fail to show up to court? What are the chances that you're a public danger? That's what matters. And if that's actually about half of what we thought it was, we should take that into account. And, you know, I emphasize this because in popular culture, like in this truly excellent TV show, which I recommend, the algorithms say, oh, 97% chance of a violent confrontation, you must intervene. And this is just not how these things work in the real world. Data is noisy, human beings are difficult to predict. There's a lot of chance affecting everybody's life. So it's important to recognize that even at the highest risk levels, according to these algorithms, it's not 97% chance that you'll go and do something bad if we release you. It's 20, 30% max. So we need to be a bit modest about what these algorithms are telling us. Okay, I'm of course running short on time, but I want to quickly ask this other question. Does the data really mean what we think it means? So what do I mean by that? So if you look at a lot of the training data and a lot of the data that is fed to these algorithms, There are these things that computer scientists call bits. They're just a 0 or 1, a yes or no, a binary distinction, that's all. So for instance, there's one bit for did you fail to appear, okay? Did you fail to show up to one or more of your court hearings? Well, was that your kind of, your preliminary hearing about pretrial supervision? Was it your trial? Which was it? There's a single bit for where you were rearrested for a crime. Well, was that some minor charge or were you trying to hurt somebody? Similarly with parole, I'm just going to flick through this. With parole, for instance, oh, you violated your parole. Well, was that a technical violation where, for instance, you went outside the range of a GPS anklet, which, by the way, the GPS anklets sometimes malfunction and produce false positives? Or did you go out and try to commit a terrible crime? Well, this single 0 or 1 doesn't tell us which one that is. The algorithm doesn't know which one it is, okay? And so it's important when we measure the accuracy of these algorithms and when we think about deploying them to dig deeper into this. And I'm happy to say that some of these studies that are being done at UNM are some of the first that ask, oh, you were rearrested while awaiting trial. Well, was it a major charge or a minor one? Was it a violent charge, drug-related property, and so on, and look more deeply into that data. So that's very important. Another issue is, and I kind of already touched on this, so the goal is not, computer scientists think about predicting things, right? For us, again, it's this math problem. Oh, tell me some 0s and 1s about the defendant. I'll try to predict this thing about them. Well, the goal is not to predict failure or success, but to help you succeed. For instance, rather than predicting that you'll fail up to show to court and then detain you on the basis of that prediction, it would be a lot better to figure out how to help you show up to court and be treated well by the system. I already mentioned these text message reminders, which are very effective. Also providing transportation, providing evening and weekend courts, providing warrant amnesty courts where you can go in a less adversarial setting and, figure out how to resolve charges against you and avoid snowballing charges leading, up to a warrant for your arrest. These sorts of interventions are, I think investing in these are often more important than investing in a predictive algorithm. Finally, as I said, algorithms, they take historical data, they look for patterns in that historical data, and they then assume that those patterns will persist. Well, this could be good or bad, right? On the one hand, it could help us see facts about people more clearly. For instance, the Arnold PSA and the research that went into the Arnold PSA, in some ways, the most important take-home message there is most defendants will show up to court and will not be rearrested while awaiting trial, right? Most defendants will succeed in those cases. Actually being a flight risk, actually being a danger to public safety is quite rare. That's part of what the Arnold PSA tells us, right? So that's an example where just looking in a clear-eyed way at the data, even if it's historical data, is helpful. On the other hand, there's also a danger that algorithms might perpetuate historical biases or historical patterns. So for instance, there's some concern that predictive policing algorithms, by continuing to send officers to areas where a lot of crimes are reported, could perpetuate patterns where some areas are over-policed and others are under-policed. So it could go either way, right? And it's something that we need to look at, and we need transparency in order to look at it. And whenever we think about should we use an algorithm or not, what we're actually doing is creating a joint system of humans and algorithms, what some people call a socio-technical system, and we need to think about that whole thing. And my hope is that by thinking about algorithms and demanding that algorithms be transparent, what we're doing is actually helping grow the public debate about justice and reform in our society overall, not just the computerized part, but the human part as well. And that demanding transparency in algorithms could lead to demanding transparency in the human parts of the system as well, so that we can better understand police behavior, which cases are prosecuted, which defendants are actually detained when prosecutors bring motions to detain, and so on and so forth, so that we can say, hey, how does this entire system work? And is this entire system fair and equitable to everyone in our society? So, okay, I want time for discussion. I just want to say 2 more minutes about one of the most basic questions. Should an algorithm ever be used to actually detain someone? Okay, so what am I talking about here? Well, what do we actually do with your scores, right? So the Arnold PSA produces these scores for failure to appear, FTA, a new criminal activity, and each of these is a 1 through 6. Well, that's a score. What do we do with you? Or rather, what do we recommend to a judge? So there's something called the decision-making framework that each jurisdiction that uses the PSA has. It varies from jurisdiction to jurisdiction. It's formulated by local stakeholders, the DA, the public defender, the police chief, and so on. And so here's an example of one of these decision-making frameworks, the one from Bernalillo County. And if both of your scores are low, you see it says ROR, release on your own recognizance. Then there are these various colors that call for different levels of supervision. These might be checking in with the police station every week. It might be an ankle bracelet and so on. And then you see at the highest level, these red boxes that say detain or impose maximum conditions of release. Now, as you know, the question of whether or not someone should ever be detained when they have not yet been found guilty of a crime, well, that's a pretty deep constitutional question. And it went to the Supreme Court of the United States in '87. And Chief Justice Rehnquist wrote for the majority saying, well, yes, liberty is the norm, but in carefully limited exceptions, the state does have the ability to detain you, to take away your civil rights if you are a sufficient danger to public safety. And of course, Justice Marshall wrote a spirited dissent saying, wait a second, you're saying you can detain someone simply based on convincing a judge that they might commit a crime in the future. So a very deep question. And now, what is that standard? Well, in our new state constitution, based on what I think was an excellent decision on our state Supreme Court's part, that detaining people based on not being able to afford a monetary bond is unconstitutional. I think that was a great decision. And so now what it says in the state constitution is, if the prosecutor brings clear and convincing evidence that you're a danger to public safety, then the state can detain you. So I would argue that an algorithm score is not clear and convincing evidence. It just isn't. Why? Because all it says is that your criminal record, say, is similar to some others, which in this historical data, fairly often, although as you saw, not that often actually, 20 or 30%, committed an offense while awaiting trial or were rearrested for that. And, algorithms by their nature can only handle typical cases. They are not crystal balls, okay? All they can do is say, oh, well, you're similar to a lot of cases in the historical data. Now, and this is the source of some public debate. I mean, we've seen prosecutors in some cases say, this is crazy. The Arnold PSA give this person a low score, a 2 or a 3, but look, they're terribly dangerous. And that's because, for instance, they had been arrested in the past, but the charges had been dropped. So they didn't have any past convictions. And remember, the Arnold PSA, for good reason, does not use past arrests. It only uses past convictions. Well, but honestly, that's because historically people who just have past arrests and not past convictions are not very dangerous. If this individual defendant has something unusual about them, like maybe the charges were dropped because they intimidated a witness, well, that's why the prosecutor gets to bring evidence to a judge, make a motion and say, look, let me explain to you why this person is very dangerous. So they can make that motion and present incriminating evidence, and the defense can present evidence on the other side. And that is how it should be, right? We should not ask an algorithm to handle those unusual cases, those rare cases where detention is actually justified. So I would argue that if you're going to go as far as, detaining me rather than releasing me, algorithms are never enough. Okay, you need to judge me as an individual and allow both sides to present evidence. Okay, I'm sorry that I took as much time as I did. The discussion is always more important than the talk. Let me just say that I'm very happy to talk with any of you offline when our time today is up. So thank you again for this opportunity.
We thank you so much, Dr. Moore, for sharing your insight and background. We've got a couple of questions that are a bit related, but we'll take them one at a time. And this understanding of data. And so one of our first persons has kind of commented on the fact that the data in the criminal justice system is inherently racially biased, just because of the history of how policing has happened in the criminal justice context. What are your
Absolutely.
thoughts about trying to kind of clean, or whatever kind of efforts computer scientists and data scientists have taken to try to separate the racial biasness from the data? Or is it even possible?
Yeah, I mean, I there are some ideas out there for taking a biased algorithm based on biased data and trying to undo its biases, right? To try to kind of adjust it um, to preserve the extent to which it is accurate while making it less biased. And there are various ideas out there, but I mean, I completely agree with the premise of the question. I mean, again, if you look at studies from the Vera Institute for Justice, for instance, um, you know, all throughout the process, from arrest to sentence to charging to who gets prosecuted, who gets convicted, whether or not you get paroled, there's bias all along the way. So, I mean, I think that there's no simple way to disentangle that. We need to recognize that by their nature, what these algorithms are doing is drawing on historical data, for better or worse. And so we need to watch them like hawks, right? And that's why we need transparency. And so we're, people at UNM, and I'm collaborating with people at UNM, are looking at the algorithms that, for instance, the corrections department currently uses for prison classification. We're going to look at the PSA, where again, the Arnold folks support these follow-up studies. And we need to look at them under a microscope and tell whether here in New Mexico, they are producing biases of various kinds. So again, I think that there's no way to guarantee a lack of bias in advance. We have to have transparency at every layer of the process. How did the algorithm get designed? What data was it based on? How does it work? How does it use that data? And then, okay, you've been trying it out in Bernalillo County for a couple of years. How well is it working, both in terms of accuracy and fairness? And just as you know, in the issue of facial recognition, for instance, another huge debate, people of color have much higher false positive rates. There was just a recent example of a false arrest where a Black man was arrested because a facial recognition program said he looked a lot like somebody who had committed theft. And so when you hear something is 90% accurate, right? Imagine you have a community that is 80% belongs to a majority group and 20% a minority group. 90% accurate could mean completely accurate on the majority and only 50% accurate on the minority, because 80 plus half of 20 would add up to 90. So we can never accept these overall figures, 90% accurate. Well, how accurate is it on each demographic group, right? Are its errors biased in which defendants it makes errors on, and in what direction it makes those errors?
That's great. So Dr. Moore, our next question really ties into it. Now that we understand that the data is historically inaccurate and we work to remove the bias from data, what are your thoughts about culturally tailoring the algorithms to understand that there might be some cultural distinctions in that need to be taken into account in an algorithm?
So based on the culture of the local jurisdiction where it's applied, or the
It
culture,
could
or
be by racial groups. This person is written about Black Americans or Indigenous persons, Hispanics or Latinos that might be negatively impacted by an algorithm. What about culturally tailoring the algorithms?
yeah, I mean, I think so. This is another deep question, which gets into, which in some ways is similar to the questions around affirmative action, right? So you could imagine actually making an algorithm fairer by going ahead and telling it the race of the defendant, right? And then trying to use that information to correct the bias. And so they're advocates of that approach. I think that there are, there are some, and again, you all are the attorneys. Um, I think that there are some legal problems with using that approach in some areas, but it is one approach. I think also one thing we need to look at is, if you actually look at the algorithms that are in use today, some of them are actually not based on data at all. They're just based on the desires or the preconceptions of the users. So for instance, if you look at our prison classification algorithm, it's ostensibly mostly about predicting infractions, but there are also some things in it, like if you've committed certain types of offenses, then we're just automatically adding a bunch of points to your score. Well, that's not really because people who committed those offenses are more likely to commit infractions. It's largely because it would be a political disaster, for instance, if someone who committed one of those offenses were put at level 1 and then allowed to escape. So
I was going
there
to
are
say,
some cases, yeah.
I've got one idea. So we are really purposefully blending our tech world and our legal world. What do you think are some of the most important things that you want the legal community to think about when working with computer scientists and data scientists and thinking about these as algorithms will impact more and more areas of the law?
Well, I think one thing I want, and I want this for the attorneys, I want this for the judges, I want this for the legislators, I want people to not be dazzled or mystified by these things, right? And there's a lot of perverse incentives right now. If I'm a vendor, again, I'm obviously incentivized to tell you that my algorithm is amazingly sophisticated and amazingly accurate, even if it is neither. If I lead an agency which has spent a bunch of money contracting with such an algorithm, I also then now have these incentives, right? And these incentives get in the way of letting everybody know how it works, letting everybody know how often it's wrong, right? And it gets in the way of having everybody in the public having have a clear-eyed discussion of, again, what their strengths and what their weaknesses are. And I want to make it clear, I do think they can play a positive role. I mean, even though the historical data is biased, one thing you see if you look at that data is that, for instance, shoplifters are not a danger to the public. So there's no point in detaining them. That's just crazy. And there's no point in, saying, oh, we won't let you go because you can't afford a money bond. So there are good things in the data that we should all pay attention to. And I just want everybody who encounters algorithms, whether you're a defendant, a prosecutor, a defense attorney, a judge, a legislator deciding whether or not to use them, I want you to be like, oh, I can understand this. This is not so hard. And they make mistakes sometimes, and let's look at them.
Thank you so much, Dr. Moore.
Yes, thank you so much. We appreciate your presentation and for giving us some knowledge on this topic. We are going to go into our next session because we're running a couple minutes late. So I don't want to take too much time, but our next session will be on the Commission on Equity and Justice, and it will be presented by Justice C. Shannon Bacon and Torri Jacobus. and I'm going to read a little bit about them. So Justice C. Shannon Bacon serves on the New Mexico Supreme Court. She has dedicated her career to working for New Mexican families, spending nearly the past decade in public service as a district court judge at the 2nd Judicial District. Justice Bacon was appointed by Governor Michelle Lujan Grisham after being recommended by a nonpartisan judicial nominating commission and elected to continue to serve during the 2020 election. Justice Bacon served as the presiding judge in the civil division at the 2nd Judicial District Court. She presided over thousands of cases spanning complex civil litigation, class actions, adult guardianship and conservatorship cases, real estate and contract disputes, election issues, domestic and children's court cases, and appeals. Additionally, Justice Bacon has served the community on numerous commissions and committees, including the New Mexico Supreme Court Adult Guardianship and Conservatorship Steering Committee, the Access to Justice Commission, the Bernalillo County Pro Bono Committee, the Supreme Court Personnel Rules Committee, the Supreme Court Rules of Evidence Committee, and the District and Metropolitan Judges Association. She has also volunteered her personal time on several nonprofit boards, including Casa Q, Cuidando los Niños, Southwest Women's Law Center, Emerge New Mexico, and the Albuquerque Community Foundation. Justice Bacon and her family are avid balloonists who have participated in the Albuquerque International Balloon Fiesta for over 40 years. We also want to welcome Torri Jacobus. Torri Jacobus is the head of the City of Albuquerque's Office of Civil Rights and Managing Assistant City Attorney in the Office of the City Attorney. She is expanding the city's initiatives related to documenting and addressing reported civil rights violations. Additionally, she provides legal guidance to the City of Albuquerque in an effort to develop, promote, and implement policies that reflect the city's commitment to equity and inclusion. Before joining the City of Albuquerque, Torri served as the director of the Center for Self-Help and Dispute Resolution for the 2nd Judicial District Court, where she further developed and managed the Settlement Facilitation Program, Arbitration Program, and services to self-represented litigants in the largest court in New Mexico. Torri serves on the New Mexico Board of Bar Examiners, the Board of Directors of the New Mexico Women's Bar Association, as Vice President of the New Mexico Black Lawyers Association, the Board of Directors of the University of Arkansas Law Alumni Society, and as Chair of the City of Albuquerque Domestic Violence Task Force. Both Torri and Justice Bacon serve as members of the steering committee for the recently established New Mexico Supreme Court Commission on Equity and Justice, with a charge to study issues related to race and bias in the state's justice system and promote diversity among judges and judicial employees. So I'm going to turn it over to Justice Bacon and Torri Jacobus.
Thank you, Asia, and thanks for inviting us to be here today to talk to you about the Supreme Court's newest endeavor, the Commission on Equity and Justice. Torri and I are going to walk through a lot of information, but we also want to encourage questions so that we're not just talking into a void. And Torri has graciously both put together our PowerPoint presentation and has agreed to drive it because I am incompetent in those matters. So thank you for being here today.
Yes, I echo Justice Bacon. Thank you, Asia, for such lovely introductions. Thank you all for coming to hear us talk about something that we're really, really excited to share with you. Justice Bacon, as we get started, can you see my screen?
I can.
Okay, then we're gonna take off.
All right, just to tether this, and we'll talk a little bit more in detail about both the Judicial Code of Conduct and the Rules of Professional Responsibility in a little bit, but we are the ethics portion of your time, so we wanted to make sure and start off with some information about the rules right out of the gate. The Judicial Code of Conduct and the Rules of Professional Responsibility already address much of the work and the goals of this commission. As most of you are likely aware as practitioners and/or judges, Bias, prejudice, and harassment have no place in the court system or in the legal system, and our rules reflect that. One of the interesting things we wanted to highlight for everyone, however, is while prohibition on engaging in conduct that is labeled bias, prejudice, and harassment has been present in the Judicial Code of Conduct since 2012, it wasn't added to the rules of professional responsibility until 2019. So we're glad it's there. It was a long time coming and we have a lot of work to do. And that's what we're going to talk to you about today. So where did this come from? And Torri pushed me to talk about exactly what it is I told her. It was in the wake of social unrest, in particular George Floyd, that I was really struggling with what I could do as a justice to address issues of race and bias. And I was struggling with what systems do we already have in place in the courts. And initially I thought, well, maybe I can accomplish some of this evolution through the Access to Justice Commission, which I'm actively involved in. And so I kind of hit the pause button, thought, okay, I'll focus there. But then I was awake literally in the middle of the night. It was like 2 o'clock in the morning. And I thought, there's got to be something else that we can do. And Google is a magical device. And I started poking around and realized that there were other courts that already had what they labeled diversity commissions. And I thought, well, that maybe the Supreme Court needs to consider something new. And with that thought in mind, I reached out to Torri and we went out for coffee and started talking about what a commission should look like, and putting together a proposal for the Supreme Court to consider. It was presented to the Supreme Court, and I am forever grateful that my colleagues agreed that this was important work that the judiciary needed to engage in, which is looking inward at what the judiciary's role is with respect to issues of race and bias, what our shortcomings are, because until we do that self-critical examination internally, how can we comment on what anybody else is or is not doing? So that the work of the commission and the existence of the commission was established by order on October 19th of 2020. And now Torri's going to talk about how we came about putting together our steering committee.
Thank you, Justice Bacon. So yeah, we were very deliberative about who we wanted to serve on the steering committee. We wanted a small group of people who were committed to the anti-racism, race equity, anti-discrimination work that we want the commission to address. But we also needed people who had a deep understanding of the judiciary and the challenges that the judiciary faces. So we had several meetings, Justice Bacon and myself, to determine who was most appropriate to sit on our steering committee. And we ended up with New Mexico Court of Appeals Judge Brianna Zamora, Taos Pueblo Judge David Eisenberg, Professors Vinay Harpalani and Professor Sonia Gibson Rankin, who are UNM School of Law professors. And we selected those two professors because they are national Constitution law scholars, national civil rights scholars with a deep, deep understanding of implicit bias and other related issues. And our steering committee started meeting, I believe, in July. And we worked together to craft the initial mission and vision of the commission. And that helped drive the development of the order that the Supreme Court issued on October 19th. We, in doing this development, we surveyed all 50 states and some international entities to see what work they were already doing in this space, to see what exists and what we could build upon. And so we've gotten quite a few questions on why did we choose equity rather than equality in the title of the commission? Why is that our focus? And so I love these pictures. And so look closely. In the first picture, you have 3 people of varying heights who were standing on 3 different boxes in order to see over the fence to see the soccer game. That's equality. Equality presumes that everyone benefits from the same supports. And so by treating them equally here with the same size boxes, that doesn't allow for all 3 of them to overcome the barrier that is the fence. The second image demonstrates equity, and that's where everyone gets the supports that they individually need in order to produce fair results. And so look at the picture again. The 3 people, the first person doesn't need a box at all to see over the fence. The second person needs 1 box, and the third person needs 2 boxes. So they each got the tools that they needed in order to overcome that barrier. And so similarly, we want to create a justice system that allows for all persons to access the benefits of it. And in order to do that, we need to address the individual differences of everyone coming into the court and how the barriers impact each of them individually. Then we have a third slide. That's our true goal. Excuse me, a third picture. That's justice. In the justice picture, the fence was removed and replaced with one that did not obstruct their view. So justice at its core requires that the causes of the inequity be addressed and those barriers to be removed. And so fundamental to our planned work of the commission will be identifying and removing those structural barriers.
So we have mapped out for ourselves the steering committee, and then hopefully will help with the guiding the work of the commission itself. And the Supreme Court has adopted these basic goals for the commission. And we're going to walk through those. The first 2 kind of go hand in hand, but goal 1 is to give New Mexicans equitable access to the state's justice system. And that's a really broad sentence. And so we thought we should describe for you all what we are thinking about by using these words. And what we have is, we obviously want to address and eliminate overt racism and bias. And overt racism and bias, while challenging, is the easiest to identify. And when we say in the judiciary, we are talking about in the behavior of anybody involved in our system. So judges, court staff, court security, the conduct of lawyers and litigants in the courtroom, of jurors. And then we need to work on the education and understanding of everyone that works in the judiciary of implicit bias. The courts have scratched the surface in terms of judicial training on educating judges about what implicit bias means, what it means to the individual, how to identify what your own implicit bias is, and how to remedy decisions you're making and actions you're taking based on implicit bias. And then the third category is something that's more symbols of racism and bias. And Torri and I often refer to this as the wall of white guys. That's our shorthand for this other item that infects courthouses and all government institutions. But in many courthouses in New Mexico, litigants walk in the door and they are met with historical pictures and archives of the court that reflect the history of a white male dominated judiciary. And so we want to, and here's a great example. These are photos from courthouses in New Mexico. One, the bigger picture towards the upper right-hand side is right in the entrance of the courthouse. The others are in the primary courtroom in the courthouse. And you'll see that in the big main picture that there is a woman on the wall, but Torri and I both have agreed that we think that's probably the clerk of the court. Because it was a white male dominated profession. And when people through imagery and language are met with things like photos like this, it gives people who are not white men a distinct sense that they don't belong and that they're not going to get a fair shake. And so we also want to address what a user's experience is like when they're going through the justice system. So that's what we're talking about with goal 1. And then goal 2 is really addressing transparency. And transparency is going to require, I think, some of the harder work that the court has to do. We need to be able to track data. For example, what are the sentencing practices of any particular judge, and does that reveal racism and or bias in the decisions that they're making, and transparency about how court proceedings are conducted, and how do you create a feedback loop for anybody in the judiciary about what they're doing well or what they need to improve on, aren't doing so well with. And we want to be able to increase that transparency so that it's not a mystery as to what's happening in the judiciary and the judicial system as a whole.
And goal 3 focuses on the categories, the people, the groups that we want to eliminate biases and inequities against. And so we were very thoughtful as we created these categories. Race, ethnicity, color, national or tribal origin, ancestry, citizenship, religion. So it's a long list. Gender, sexual orientation, gender identity or presentation, and physical disability. Those are all pretty established through federal, state, and local law. So those were obvious. We knew we had to add those, but we knew that there were categories that those groups didn't meet that still experience barriers and challenges as they access the court system. So we had to go beyond that and think about what were those categories. So indigent status was one of the first ones. We recognized that people who are experiencing poverty may present differently in the courthouse. They may not have professional clothing or other benefits of wealth that would lead to them being penalized as they step into a courtroom or just the courthouse, just at the front door of the courthouse. We spent a great deal of time on the mental or developmental disability or condition language because we wanted to go beyond mental disability alone and cover mental illness and other neurological conditions that may present barriers but may not be technically disabling conditions. English language proficiency is a huge barrier in the courts, and each court does have a language access plan in place that guarantees members of the public, litigants, access to interpreters. But the steering committee felt that the courthouses, the judiciary as a whole, could benefit from more language around how we interact with the people using interpreters, how we provide access to the interpreters. And then parenting status or pregnancy was an interesting one. Justice Bacon will tell you that she hadn't given that one any thought until we brought it up. I'm a parent and I've been pregnant practicing in the courthouses. And there are small little things. Sometimes parents have to bring their children to court, both lawyers and litigants. And how do we address that? How does the court as a whole respond to that? There's also parenting status or pregnancy may create perceived barriers to becoming members of the judiciary. Part of what we're going to work on is creating a pipeline to the judiciary. So how do we make that a more attractive profession and path for those who are parenting? And then there's also the fact that parenting status tends to disproportionately impact women more than men. And so we have to make sure to capture that people in order to provide true support and true acknowledgement of the barriers that women experience in the profession and as they interact with the judiciary. And then, of course, we have our catch-all at the end of other characteristics identified by the commission, because we recognize that the 6 of us may have missed something. We may not have captured everything that we need to in order to make sure that our court system is fair and equitable to all people who come into it. And then we're returning right now to Rule 16804 of the Rules of Professional Conduct. And this is misconduct. Excuse me, I'm so sorry. This is 21203, bias, prejudice, and harassment of the Judicial Code of Conduct. I'm not going to read it to you, but if you take a look, this prohibits a judge by performance of judicial duties, words, or conduct from manifesting bias or prejudice, including harassment. And then it lists the types of categories that we used on the prior slide and that we used in creating the commission. The judge also shall require that lawyers proceeding from them refrain from manifesting those same behaviors. The judges have a duty to intervene when they see this behavior. And as Justice Bacon stated, this has been in effect since 2012. While 2012 was 8 years ago and feels like quite a long time ago, that's actually very, very recent. And it's a bit alarming that the court did not see a need to put in place this rule before that time. Justice Bacon, do you want to add anything on that?
No, I mean, just a little bit. I shouldn't say no. I think one of the biggest areas for judges to improve upon and be trained is how to disrupt behavior in the courtroom that fits in these categories. I think lots of judges know how to control their own conduct, at least their overt conduct, as opposed to their implicit bias. But giving judges the tools to interrupt this behavior while it's happening real time in the courtroom is going to be really important to achieve the goals of 21-203.
Thank you. Then our next slide is what I was trying to jump ahead to, professional conduct for attorneys. And this is 16804G. And it pretty closely mirrors the requirements for the judges. Unfortunately, this one wasn't put into place in December of 2019, so less than a year ago. And lawyers have a duty to report when they see other lawyers engaging in this type of behavior. But as Justice Bacon said regarding judges, it's hard to interrupt and report and deal with the behavior that you see in your colleagues. And so part of what our work is going to do is to help provide ways in order to be interrupters and redirect our colleagues.
All right. Goal 4 is really focusing on educational and professional opportunities for prospective lawyers, judges, and employees from underrepresented groups. And this kind of falls into two distinct categories. One we refer to as the pipeline, and that's where we're focusing on lawyers and judges. And then with focusing on employees, we're looking at policies and procedures in the judiciary to assure that they give everyone a fair shake in applying for employment, but also focusing on what does a diverse workforce look like. We want the judiciary to be reflective of our community. When it comes to educational and professional opportunities for lawyers and judges, a couple of things that we talked about extensively in the steering committee are pipeline programs for externships and clerkships in the judiciary. And we've already made progress in that regard. Justice David Thompson, who's very active in the ABA, has brought the ABA diversity clerkship program to the New Mexico Supreme Court and the New Mexico Court of Appeals, which is being implemented this year, which provides through an application process what we're calling a clerkship. It's more akin to an externship because it's during law school for students who are underrepresented and have various barriers to seeking judicial clerkships. And there's a stipend that comes along with this particular program because the court recognizes, and the state bar, which has been a great partner in this, and the Young Lawyers Division, who's also been a great partner in this, recognize that oftentimes the reason law students don't extern is because they can't afford to extern. They need to have a job during the summer so that they can keep their lights on. And that disproportionately impacts law students of color. And we also, so that was one piece of the puzzle. And this clerkship program also provides mentorship throughout their experience with the appellate courts on how to apply for judicial clerkships when they're finished with law school. So there will be mentoring assistance with writing samples and making resumes, interviewing, all of the things these students need to put their strongest foot forward, and we can start to diversify the clerkship programs within both appellate courts. And one of the reasons to me that this is really important for the future diversity of the courts, and in particular the appellate courts, and it struck both Justice Thompson and I that this was borne out by our recent appointments to the Supreme Court, and then also the appointment of Judge Shamara Henderson and Judge Zach Ives to the Court of Appeals, that all four of us began our legal careers clerking in New Mexico appellate courts. And so you can draw whatever conclusions you want from that, but it seems that a large percentage of at least appellate judges in New Mexico have a starting point of clerking themselves in the appellate courts. And so if we don't diversify that process, we are going to fall short of our goal of diversity in the judiciary, which is critically important.
Justice Bacon, you alluded a little bit to the demographics of the judiciary right now. Can you elaborate on that a little bit?
Sure. So the New Mexico has done a good job with gender balance in the courts, and has done a reasonably good job in terms of ethnic diversity if you look at the balance of Anglo judges and Hispanic judges. But where we really fall short and are quickly falling further and further behind our representation from the African-American community, Native judges, and Asian judges. New Mexico has one Asian judge today. In 2.5 weeks, it will have no Asian judges because Justice Nakamura is retiring. We have I would call a critical underrepresentation of Native judges in New Mexico. It simply does not reflect our community. And the number of African-American judges has dropped over the course of time due to retirements. And so we need to be very mindful and deliberate about populating the judiciary with people who reflect the composition of our community. So it's not all terrible, but there is lots of room for improvement.
So here we have 4 slides that are going to talk about the commission, the composition of the commission. And before we talk about the specific individuals, I want to share how we came about this list. As Justice Bacon mentioned, she sits on the Access to Justice Commission, and I'm not a voting member, but I'm a interested community member who shows up to their meetings. And one of the really great things about that commission is that they have, what is it, Justice Bacon, 15 voting members? So they have about 15 voting members. They have about 50 other people who show up to the majority of the meetings. And everybody who shows up is guaranteed a seat at the table in pre-COVID world and the theoretical table via Zoom. And every voice matters. And so we want to mirror that and create a commission where every person who is in the room, every voice will be a part of our decision making and included as we go forward, because we recognize that it's impossible to have a voting body that is representative of every issue and every challenge that's faced in the community. So first on our list is, of course, we want a Supreme Court justice and a Court of Appeals judge on our commission. And Justice Bacon, I think you're probably best suited to speak to why we need those.
Sure. If we're going to engage in self-critical examination of the judiciary, you need buy-in and representation from all levels of court. And we don't want to have too many folks from the appellate courts, but you certainly want individuals that provide representation from the appellate courts to engage in conversations, but in particular with the Supreme Court, because the Supreme Court sets policy directives for the entire judiciary and influences policy directives for the entire bar. And so having a Supreme Court justice at the table is important for that reason, so that there is free-flowing information from the commission to the Supreme Court and back and forth.
And then, as Justice Bacon said, we want every level of the judiciary represented. So we need district and metro court judges. But more than that, we need, Taos Court is considerably smaller than Second Judicial District Court. And so we recognize that. We recognize that size of court matters. That changes the resources available to that court. That changes the resources available in that community. So we make sure that we want someone from a small, medium, and large court, and then one at-large member who can come from any of those three groups. And then we need a magistrate court judge, because magistrate court judges, they have different experience than our district court judges. And that experience may play into how we want to share our education and our tools with them. Do you want me to keep going?
Sure, or I can jump in. I mean, I think having a tribal court judge it goes without saying. The state courts and the tribal courts in New Mexico have a very strong relationship and conduct their work through the tribal state consortium. And we have probably one of the better relationships between state courts and tribal courts in the country, because of deliberate interaction and collaborative work between the two court systems. And we need to continue that with this particular commission as well.
And as we talk, go ahead.
Go ahead.
Well, two things. One, I'm going to go off script for a moment. We talked about parenting status earlier. Well, there's a 9-year-old just off screen who just reminded me she didn't take her medicine at lunch. So I'm trying to pretend like I'm still looking over here and not looking at her. But I'm sure you all see some awkward movements on my part. So my apologies. But so we mentioned the pipeline to the judiciary, and that requires a committed relationship with the UNM School of Law. Justice Bacon mentioned the new externship program, and that requires talking closely with the Career Services Department, with building capacity in the law students, and then also just beyond that, creating conversations in the law school that lets every law student know that they are building and will have the skills in order to apply to be a judge one day. I talked to a group of UNM students yesterday, and I told them, 15 years ago when I was still in law school, I never imagined that I was the type of person who could apply to be a judge. And I don't know what messages I was receiving that made me feel so negatively about my own abilities. But I want to make sure that this current batch of law students and everybody who comes behind them, they each are empowered to know that they can accomplish any position within the judiciary, and that we, the rest of us in the profession, will give them the tools they need to do that.
And then next we want and need attorney representation. We are hoping to have attorney representation that includes somebody from the public defender's office, somebody from the prosecutorial side, someone with expertise in children's court, and then somebody with civil court representation. And these, are the four main categories of attorney in New Mexico. We recognize that, there's domestic relations, but that's bound up in civil court. And it's so that we understand what's actually happening on the ground in courtrooms, in litigation, from the folks doing the work and also representing individuals who face these challenges and obstacles when they're coming into the courtroom.
And then on a related note, with on the ground, we need a community advocate. We need someone who's not quite as intertwined in all of this as the judges and the attorneys are. We need someone who is out there working with the litigants on a day-to-day basis with their life needs, and so that we can incorporate the ways that our personal lives can impact what happens as one comes into the courthouse. And then we also need a human rights or civil rights representative, and this person will pay special attention to making sure that we stay connected with our protected classes and the ways that the protected classes can impact what happens in the judiciary, what happens in the courtroom, and then also can bring in some expertise on implicit bias and anti-bias work.
We also want a mental health advocate. And one of the ways in which you see bias really overtly demonstrated in courtrooms is a judge's interaction with somebody who is struggling with mental health. And I think one of the main reasons for that is judges are not trained in any functional way to communicate with individuals struggling with mental health issues without triggering the litigant. And a lot of work needs to be done in this arena. And so we thought we should have someone at the table who can help guide those conversations and determine what policies and procedures might need to be changed and what kind of training would be effective to make that experience better for the individual experiencing mental health challenges in the judiciary. We also focus then on some individuals who work in the building, and the two here, or actually three, I think will hopefully make sense to everyone joining us today. We want somebody from court staff. We need to hear from individuals, say in the clerk's office, and what their policies and procedures are like, and what kind of we need to steer what kind of training they receive. And so we want representation from court staff. Same with the court security officer. The way we approached this is, what are the different stages a litigant or a customer goes through in the court experience? And often their very first experience is with court security. And then it might be then next to the clerk's office, or it might be to the self-help center. And those are the three kind of key areas in a courthouse a customer experiences before they come to upstairs to a courtroom, or down the hall to a courtroom. So that's why we want court staff, a court security officer, and a representative from a self-help division, one of whom is going to get an arm twisting at the end of this video, Asia Brooks.
One of the reasons why self-help representative is so important is that about 50% of the litigants in civil matters are pro se. So those are the people where they won't have an attorney to help guide them through the process, but they will be checking in with the self-help center in theory. And so the self-help center will see some of the issues that would never rise to the level that a judge would see. And so that self-help representative, Asia Brooks, will be critical in assisting with crafting policies specifically for self-represented litigants. And then we want a legislative person on here because we recognize that some of the changes that we create may require solutions that go beyond the judiciary, that may require legislative changes. And so we need someone at the table to help us see where those places are, and then to help us navigate through making those changes, or requesting and recommending those changes.
And then we have 2 at-large positions to capture individuals we haven't thought of, or instances where we have more than one individual who's qualified for any particular category, but based on their experience and qualifications, we really want them to be at the table. The Supreme Court as a body pushed for the voting members to stay under 20. So we had to make some hard decisions and really try and craft what we think will bring the right voices to the table in terms of voting members. But as Torri pointed out earlier in her presentation, we also want a really broad representation of ex officio members to the commission, and we've modeled it after the Access to Justice Commission as she described. So Torri, you want to talk a little bit about the ex officio members?
Yes. And it's actually kind of hard to talk about this without just reading the slide, which I'm going to try my darndest not to do because y'all didn't come here to see me read today. And so what we wanted to do is we wanted to reach out to and have a representative from all of the diverse bars. So Women's Bar Association, the Hispanic Bar. See, I'm reading to y'all. But we wanted to make sure that there was a bar association. If it represented a special interest group, we want them at our table. We want them to send a representative. And then there are also some state bar committees and divisions that we wanted to make sure to include, such as Young Lawyers Division or Committee on Women in the Legal Profession. And then we also want representatives from corrections and probation and pretrial services, because they see a different part of the legal process that needs to also be taken into account. And as Justice Bacon mentioned, we really wanted, this really large voting pool, and the Supreme Court dialed us back a little bit. And so although these are ex officio members, they are no less important, and we need these people there as well, or else our work can't be done. We won't be informed enough in order to do it. And then we also need multiple representatives from several judicial entities. And this includes court CEOs. Those court CEOs were one that one's huge for me, because the court CEO, that's the person in charge of each individual court who creates and executes the policy for that building. And so if we don't have buy-in from the court CEOs, it will be a lot harder to push down the policy changes that we want to see. But then there are also some interesting extra ones that I wouldn't have thought of initially, like the law library. The law library frequently sees self-represented litigants, and much like the self-help office, they get different questions than anyone else in the process may receive.
And most of the customers at the Supreme Court Law Library are self-represented litigants and prisoners. Vast majority of individuals that access the Supreme Court Law Library.
And then we also want a member from the Board of Bar Examiners present. And that's because they have access to some data that we're going to talk about a little bit later, but some data that's really critical for assessing our profession. And then we also want representatives from New Mexico Legal Aid, Center on Law and Poverty, and other agencies that deal with poverty law and indigency related issues. These groups are really on the ground with the community in ways that most lawyers don't frequently engage.
And before we move on, Torri, I want to turn to one of the questions we've been answered because it fits right into this section. And it's a question, I'm interested to learn how you think the 80+ municipal courts and 33 probate courts would be included in this work. And what I'll explain, at least with the municipal courts are a very different animal in terms of our court structure. And they are part of the larger hierarchy, same with the probate courts. But our interaction and work with those courts at the Supreme Court level is quite different. And it's not to exclude anybody from the municipal courts or the probate courts from this work, but we had to make really hard choices about what courts we were going to focus on first and who we wanted to be part of that voting membership. As you can see, our ex officio membership is as broad as it possibly can be. And we will encourage representation from those two courts if we can secure it.
So we need you all to apply. We need you to share the word about our commission. The Supreme Court is presently accepting applications. It's a 2-page limit, so hopefully not too burdensome. In that 2 pages, though, we'd like to see that the applicants tell us why they want to serve on the commission, what they bring to the commission, and then their prior demonstrated commitment or professional experience, what diversity, equality, equity, inclusion, and anti-racism. The deadline is next Wednesday at 5 p.m. And then once we receive these, the steering committee is going to review them all and make recommendations that the Supreme Court will consider. The Supreme Court will have the ultimate decision on creating the commission membership. And then we intend to let people know mid-December, I believe, Justice Bacon. Is that accurate? And then have our first meeting in January. Yeah, all going according to plan, mid-December with our first meeting in January. We're really excited to get going on this work, and we are really excited to get our pool of people together. So again, please, please, please apply. And if you don't feel like this is something that you have capacity for or that meets your area of interest and professional experience, just spread the word for us. And then especially with outside of the outside of the legal profession, spread the word, because there's several positions where we need non-lawyers. And then what comes next? What are we planning to focus on first?
There's so much to do, and some topics are much easier than others. So these are kind of general items that the steering committee has identified as a starting point for working groups to really focus on how to accomplish these kind of big, laudable goals. So obviously we've talked a lot today about training and education of both judges and staff. So we will be working hand in hand with the Judicial Education Center to make sure that in all trainings for judges and staff, there is a component to the work that's being done at the Judicial Conclave, for example, that focus on issues related to racism and bias. And while we obviously need to kind of set the table in terms of the implicit bias, we view that as like the baby step, and we want to have a much more sophisticated long-term plan for the training of the judiciary as a whole about racism and bias. We also want to gather New Mexico bar data. And a good example of this was brought up to me in a different presentation by a law student. And the question was, in the screening for bar applicants, the fitness and character screening, is there a disproportionate exclusion of people of color when they're applying to become members of the bar? And there were 3 justices in that meeting with the law students, and none of us could answer the question. So that's a really good example of the type of data we want to start to cull and examine and understand. But there will be all kinds of data that we can gather by working hand in hand with the state bar and with the Board of Bar Examiners. We talked about the creation of a diverse pipeline to the judiciary in terms of clerkship and externship, but this also really focuses on judicial nominating commissions and the need for a more diverse representation of individuals on judicial nominating commissions. As it stands, the rules require political diversity between the 2 major parties. It focuses on practice diversity. So you have some folks that do criminal, civil, DR, things like that, and it focuses on gender balance, but it doesn't, the balancing doesn't go well beyond that into race and ethnic diversity. And that's something that needs to be addressed. Torri, you want to talk about the other ones?
Sure. Okay, court observers is actually kind of fun. This one we found out about, Justice Bacon and I found out about as we started doing our research about what happens in other courthouses. So one way that court observers work is that they are anonymous visitors to the courthouse who observe judges and observe lawyers in action in the courtroom to see what types of behaviors are happening, to do firsthand reports on any bias or exclusion that they are seeing in the courthouse, and then report back. And then AOC or the Supreme Court can take action and help remedy those problems. Then another piece is just looking at each courthouse from the front door all the way through to, if it's a criminal matter, through sentencing, about what does the courthouse look like? What is the experience like? Are there ways to make going through security more accessible and more open to all people who are coming into the courthouse, while also, of course, keeping a secure building? The artwork on the walls, is it diverse artwork? Is it artwork that reflects our community? Justice Bacon and I learned about a study that says that if diverse artwork is included in sentencing rooms, it affects outcomes for people of color. And then also she shared the pictures of only white judges earlier. As a woman of color, as I walk into a courthouse and see pictures of only older white men, I feel like there's not a place for me. So our court observers are going to look at things like that and make sure that our courthouses create a place for everyone who's walking in. And then the next one is review case outcome data. I'm going to touch on this one, but I'm going to pivot back to Justice Bacon on it. But right now, the courts don't keep data based on case outcomes and verdicts based on race and gender and the other categories that we talked about earlier. And we acknowledge it's a little bit scary to think about keeping this data, but we suspect that there are some problems related to implicit bias within the judiciary. And if we don't have the data, we really can't do targeted enforcement or enforcement of changing those problems.
And this is probably one of the hardest bullet points on our kind of to-do list. Tracking case outcome data, that structure doesn't exist in our IT system of the judiciary. So that's a challenge. It's a fiscal challenge, it's a time challenge, technology challenge, but also in other states that have attempted to track case outcome data, whether it's harsher sentencing based on race and ethnicity, or a civil judge who doesn't grant summary judgment to a movement universally because of the way that person looks or appears. The pushback from judges to collecting this data is very significant. That's been the experience of other states that have tried to track this information. So we view that as one of the toughest areas for the commission to tackle. And then the last bullet point is review and reform all policies, procedures, and jury instructions. A quick example of that is one, I can't remember off the top of my head which state it is, but a state in the US recently created a new uniform jury instruction that instructs the jurors about implicit bias. So that's a really good example of looking at jury instructions and rules and figuring out how to make systemic change within those policies.
Then this actually is the conclusion of our presentation. I have a contact us slide here, and Professor Rankin has popped up, I know, to let us know we're near the end, and I hope to share some questions with us.
No, thank you so much, Justice Bacon, Ms. Jacobus. That was a fantastic presentation, and we've got a great set of questions in our queue. We'll try and get to as many as we can. A person is interested in how you think the 80 plus municipal courts and 33 probate courts would be included in this work.
Sure, I touched on that briefly a few minutes ago. In terms of, the voting membership, the Supreme Court gave us a very clear limit, and we had to walk back how many voting members we had on the commission, but we want the work of the commission to be very broad-based. And there is a seat at the table for anyone who wants to participate. And we also plan on ensuring that we actively recruit and encourage people to come and join us to have that conversation. So those two groups will be included in that work.
Thank you. Our next question is slightly along the same lines, but that it appears that the one magistrate court judge could potentially be the only non-lawyer among the legal profession members of the voting members of the commission. Given that many magistrate judges in the state, especially in the rural areas, why not include one or more of them, perhaps to replace one of the at-large district court, metro court judges?
So the structure of the judges, the law-trained judges on the commission is a very traditional approach from the Supreme Court, and it's what the steering committee also focused on. The magistrate courts have now been moved under the direct operation of the district court, so they're not standalone courts any longer. And so while we understand that that's a really important perspective, the magistrate court perspective, who see largely, almost entirely self-represented litigants, we have the one position, and then we also have at-large positions. So if there was a magistrate court, more than one magistrate court who had a desire to really dig in and do this work, we'd be happy to consider them for an at-large position.
Thank you, Your Honor. We have another question. What kind of work will be done to include representatives that represent people with disabilities?
So we absolutely want to include persons with disabilities, and we are hoping that a representative from agencies or advocates that represent people with disabilities will apply. And they qualify for the at-large position, the mental health advocate, as well as the community health advocate. And then beyond that, we hope to recruit some more for those other ex officio positions. We want everybody at the table, and we need everybody at the table. And we fully recognize that persons with disabilities have barriers that at least none of us on the steering committee are personally knowledgeable of. So we need to have the other people there to help tell us how to navigate those challenges.
Thank you. Thank you once again so much, Justice Bacon and Ms. Jacobus.
Thank you.
And thanks for joining us in this work too.
Thank you for having me. And I now turn it back over to President Asia Brooks.
All right. Thank you, Sonia. I just want to thank all of our presenters today, Dr. Moore, Justice Bacon, Ms. Jacobus, for your presentations today. This has been very, very helpful, and I love how subtle you both are, Torri and Justice Bacon, in your prompting to join the commission. But I do really hope that people who are on this Zoom webinar will apply to be members of the Commission on Equity and Justice. So please, take Torri and Justice Bacon's words and apply for those positions, because it's important to have diversity. It's important to have different views on commissions like these. Just some reminders. So tomorrow's link will not be the same as today's link or Monday's link. So we will send a link out for tomorrow's CLEs tonight around 9 p.m. If you do not receive that link, it will be from the New Mexico Black Lawyers Association. Please check your spam or your junk mail. I believe the links are going to spam and junk mail. So it should be sent around 9 p.m. tonight. If you do not receive the link for tomorrow's webinar and you are registered for tomorrow's CLE, please email us at nmblacklawyers@gmail.com. Again, that link will be sent around 9 p.m. tonight. If you have not already sent your bar number to us, please send us that at nmblacklawyers@gmail.com. If you have already sent it to us, we already have it, so you do not need to send it again. But if you have not sent it to us, please send us your bar number. So I'm hoping that everyone will join us tomorrow. Tomorrow's the last day of our Lunch and Learn series, and we will have two amazing speakers, Pamela Herndon, and who is an attorney here in New Mexico. And we will have Dr. Wendy Green, who is going to be talking about Black hair and civil rights. And so I'm just hoping that everybody joins us tomorrow, and thank you. Thank you for supporting our annual CLE.